Voluntary arbitration under Section 10 of the Industrial Disputes Act, 1947. Introduction. Section 10 of the Industrial Disputes Act, 1947 provides a mechanism for the voluntary settlement of industrial disputes through arbitration. This provision allows employers and workers to choose an arbitrator of their choice to resolve their dispute instead of going through the formal adjudication process under the Act. Key features of Section 10A. Applicability. It applies to both existing and apprehended industrial disputes. Voluntary agreement. Both the employer and the workers must agree to refer the dispute to arbitration. Written agreement. The agreement to refer the dispute to arbitration must be in writing and signed by both parties. Choice of arbitrator. The parties can choose any person or persons, including the presiding officer of a labor court or tribunal, to act as an arbitrator. Written form of the agreement. The agreement must be in the prescribed form. Publication of the agreement. The agreement must be published in the official gazette. The agreement to refer. Investigation and award. The arbitrators investigate the dispute and submit their award to the appropriate government. Exclusion of the Arbitration Act. The Arbitration Act, 1940, does not apply to arbitrations under Section 10A. Advantages of voluntary arbitration. Faster resolution. Arbitration is generally faster than the formal adjudication process. Lower cost. Arbitration is often less expensive than litigation. Flexibility. The parties have more control over the arbitration process. Confidentiality. Arbitration proceedings are confidential. Expertise. The parties can choose an arbitrator with expertise in the subject matter of the dispute. Disadvantages of voluntary arbitration. Limited appeal. The scope of appeal against an arbitration award is limited. Lack of transparency. The arbitration process may not be as transparent as the formal adjudication process. Potential for bias. The arbitrator may be biased in favor of one party. Additional points. Section 10A, 1A, provides for the appointment of an umpire in case the arbitrators are equally divided in their opinion. An arbitration agreement can include provisions for the appointment of a replacement arbitrator in case of death, resignation, or incapacity of the original arbitrator. The award of the arbitrator is binding on the parties and can be enforced through the courts. Resources. The Industrial Disputes Act, 1947.